Universal credit claimants and anybody having currently anything to do with payouts from the Department of Work and Pensions, what can they legally ask for? Now, I say legally, I am not a lawyer, this is not legal advice, but it's not too difficult to pull out the Data Protection Act and GDPR here and see a great big flouting hole where these claim reviews are and where these targeted case reviews are. So if you're on universal credit or you're applying for it and you're being asked for all and sundry, including what you actually spend your money on, then this video is definitely going to be for you. And I'm going to be pulling up one of my followers, Mad Max Brown, I hope you are following, one of their comments, because your comment is partially accurate, but indeed very misleading. And when you look at the two laws that you've quoted here, we can see exactly how DWP are doing something which I refer to as an abuse of policy. Now, before I go into this, I'm just going to reflect again from my own case on how undeniably awful the Department of Work and Pensions are in actually complying with GDPR and data protection. So much so that in my own case, the judge had to do an anonymity order. Thank goodness I said that correctly this time, because DWP and their senior managers, all listed here, and this is a public document, passed in court, so I can refer to it. All of these people here, senior managers at DWP, failed to actually redact the full names and national insurance numbers of over 300 universal credit claimants. Probably too busy trying to get their stories straight in the side room, I imagine. Anyway, let's go on to Mad Max Brown. Section 8 of the Data Protection Act 2018 and Article 6 of the UK GDPR allows for the department's processing of personal data that is necessary for the exercise of a function of a government department. It seems to me, the way you've written this, that you actually work for the government department. In this case, establishing that a claim for benefit remains as set out in the 2013 regulations. This comment is very much in response to requesting of bank statements. While the information or evidence required may include personal data, claimants would not be breaching any data protection legislation when providing that personal data, including that of a third party, in response to the Secretary of State. And I'm pretty sure that you work for the Department of Work and Pensions. So let me give you some feedback on your comment, which is partially accurate, but of course, in true DWP style, very misleading. And maybe you can pass that on to your seniors and maybe start following the law. So let's have a look at those two acts. And again, it's not legal advice, but I think we can quite clearly see when we read these acts what they mean. Now, why I'm saying that comment or statement is misleading is because when it's phrased in that way, it's being used as a justification to unlimited access of personal data. And that's one of the reasons why we have a GDPR law now. So let's unpack it really carefully. So for those of you who are watching, and if you're one of the YouTube members or you're one of our website members, you'll also have various letters that you can use to reply to organisations who are, in your opinion, and particularly in mine in this case, asking far too much information without just reason to do so. Now, I want to be very clear here. Flatly denying to comply with something is a mistake. If you just say, no, I'm not going to give you that information, and you don't qualify it with a reason why, and you don't provide a written response, and you don't point or refer to the things, the acts of parliament or things that you consider are legally correct or maybe incorrect, or partially incorrect in this case, then you're going to wade into waters that are going to be problematic. You can't just not comply or just say no. That's why the letters that we provide and the other things that we do over at thejusticejournals.com is really important, because should, let's just say, they decide to cut off your benefit and you've got nothing written down, you've got no defence, there's nothing you can prove legally in a court of law to say, well, you stated this, you argued this point, so you must always write a letter or put your point across in writing. But you must always comply, and there are lots of ways you can comply whilst still not giving them everything if you don't believe that you should do. So the DWP, obviously, as a government department, does have a legal basis, just like any other organisation or any company, under Section 8 of the Data Protection Act 2018 and Article 6, 1E of the UK GDPR Act. Now, these two acts, in particular, the UK GDPR Act and law, is considered like the gold seal of personal protection, especially in Europe. And one of those reasons is because Article 6 in particular is to process personal data when it's necessary to carry out their official functions, such as administering benefits or verifying entitlement. So in one of my other videos, when I'm talking about case reviews, and I've told you guys to ask specifically why you need to be asking what the case review is for, in order to measure what information or data is necessary, will be dependent on the function for which it's requested. So if they are not giving you a reason as to why they're collecting it, they can't know the function. So therefore, you could argue quite strongly, well, you're not complying with Article 6 because it's you have to have an official function. So yes, in principle, they are allowed to request and process some of your information, but here's the important part, and again, it's the part that is often ignored, and the reason why Department of Work and Pensions, in my opinion, ignore it is because they know full damn well that they shouldn't be doing it, but they also know that if they ask you for everything, then they will then have the very information that they would love to have from banks, but banks are not permitted by law yet to give to them, unless of course they push through the recent bill that they're trying to push through. Okay, so both Section 8 and Article 6 are subject to a key legal test. This key legal test is really important. The processing must be necessary and proportionate for the specific use. Define specific use. What is the case review for? There are many, many different case reviews done in DWP land, in Universal Credit land. They must state why are they doing a case review. Okay, so that you can then determine whether you think the information they are requesting, your personal information, let's not forget, whether it is necessary and proportionate. If they have not determined what the function is for, then they are, in my opinion, are not clearly doing this test of measurement. Okay, it must be necessary and proportionate for the specific purpose. They would have, big issues trying to explain that, I think, otherwise. So that means they cannot ask for everything just because they think they can, because they're DWP. They must be able to justify why each piece of information is reasonably required. Now, reasonably, you can hear my emphasis on the word, to establish entitlement. That's fine, to establish entitlement. They must comply with data minimisation. Now, this is one of the things that GDPR Act, in particular, the ICO in London, I'm the data processor for my company, and I can tell you now, like one of the things that they are very, very hot on is data minimization. And we've only got to look at the amount of times DWP haven't complied with this, and the ICO in London have had something to say about it, and that could be a whole new YouTube. So personal data shall be adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed. So to say we need to see if we have all of the info, like we need to verify if we have all of the information that is relevant for your claim. That in itself, just stated like that, is not reason enough to be asking you for absolutely everything. So in plain English, the DWP can ask for information that directly affects your entitlement, and watch my other videos on bank statements and case reviews. In fact, I will link them at the end of this video, because the current Social Security Administration Act and other acts that are relevant to the retrieval of universal credit, or the payment of universal credit, clearly state income, capital and student finance, or income and capital in particular. They do not state expenditure or what you spend your money on. Big difference. So if you're being asked what you spent your money on, what did you draw this 500 quid out for, what did you spend £3.82, one of you have commented in the comments, quite frankly, disgusting. Again, unlawful. So they can ask for you to verify your income. So they can ask for a bank statement if it is for a certain period of time. Know that universal credit is it's specific, time specific. So if they're asking you for the last 5 years of your bank statements, and you've only been on universal credit like 2 months, no, they can't ask for that. They can only ask for universal credit for the time period that it relates to. And universal credit is assessed on a month-by-month basis. You could even go, if you've already given information the month prior and they're asking for it again, I would be saying no. Universal credit is assessed on a month-by-month basis. I proved last month I had eligibility for universal credit last month. I'm quite happy to give you a bank statement for this month with all of my outgoings reducted, because that is my personal information, which you do not have the right to look at. And there is no current law that stipulates that you can mandate that information from me, firstly. Okay. And secondly, then, they have the right to process that data under lawful authority. They cannot demand irrelevant personal data, as I've stated, how you spend your money, or unrelated transactions. And most definitely, they cannot harvest information. They cannot do something called intelligence data gathering, just in case. That is 100% unlawful under GDPR. And also, it ignores your rights under the Equality Act of 2010, potentially if their requests are causing you stress, anxiety, or putting you at a disadvantage due to disability. So let me break this down. If you consider yourself disabled, or you have a long-term health condition, and you can, by that means, you consider yourself disabled under the Equality Act of 2010, and you can simply phone up the Equality and Human Rights Commission in London and ask them, and they will go through a questionnaire with you on the phone if you feel that you're not quite sure. Then let's just say, in this case, DWP are threatening to stop your benefits, which I've heard some people say or write in the comments. That would most definitely put a disabled person at a disadvantage. Now, I think DWP need to be very, very careful here, because again, and I really don't mean any disrespect to anybody, but the majority of people working at the Department of Work and Pensions, particularly on the ground level, the people that you're seeing when you go into the job centre, are not the brightest buttons in the box. Lots of people got employed when COVID, like when the world was in shutdown. I've had to work with some of these people, they can't even shut down appointments on a diary at the end of the day. So when it comes to handling personal information, I really don't have any confidence in them whatsoever, and after taking them to court and suing them, and how I see how they misuse information, I most definitely would not be wanting them to have like any personal information, or as little as possible. And let's not forget, again, this is your personal information. Trying to hold vulnerable people over a barrel because they require universal credit, PIP, help or support with their housing payments or something like that, and using this as a threat is, I would be taking legal advice. If I was on universal credit and I was being threatened with that notion, I would be straight on the phone to my solicitor without a shadow of a doubt, I can tell you. So just know that you do have rights. You do have to be compliant. You do have to provide information for the reasons stated. But excessive information gathering is damaging. In my opinion, it's not correct. In my opinion, it is unlawful, although this is not legal advice, I've already stated. And as we also have this digital ID looming in the background where they're trying to force that through, I would be very, very, very careful about the amount of information that's given to certain people. Anyway, enjoy that. Please don't forget to subscribe and follow, and share this channel out with all your good friends and family, close ones, people who you think need some straight plain talking and, the BS debunked. Anyway, have a great day, everyone. Goodbye.